All right, let's take you to one of our top stories that we're following for you. That's the Senzo Meyiwa trial. The start was interrupted yesterday by discussions around whether the media should be banned from court. This after 3 media houses, including eNCA, tried to interview a state witness before court proceedings. The judge had some harsh words for the journalists involved. Today, we talked to legal expert Mpumelelo Zikalala about that very incident. Could journalists have jeopardized the state's case? Mpumelelo, good morning, and thank you as always for your time. A very rocky start to proceedings yesterday. What did you make of the judge's decision to ban the media for a short while? But also, what does this mean for the state's case going forward?
It was a correct one. The judge had to send a very stern message of saying, please do not disturb the working of this particular court. We're doing a very important job. And if we keep engaging in this particular manner, that's where we are going to find, or we can't function as a proper court. Let's also remember, there's also an element of crime in this type of proceedings. Obstructing or the course of justice is exactly that. If you're going to interfere in the manner in which a court is supposed to do its work, that's when you're going to have a problem. When a person has been invited or subpoenaed to come and give evidence, the only time in which that evidence should be heard for the first time is inside the courtroom and not outside. So the balancing act of saying, we want to keep the people of South Africa well abreast and updated as what is happening in court must be well balanced with protecting the integrity of what is going to happen inside court or information that ought to be stated once it has been stated inside this particular court. Another element of it is this one of saying, to be a witness is not an easy process, especially in a matter which is as high profile as this one. So you have to make sure that you're able to protect the witness at the end of the day, be well aware that they're going to testify about their friends. So if anything, we should be sympathetic to them and say, let's try and assist you. All that we want at the end of the day is to extract the truth. So we're going to assist you in all our might so that at the end of the day, you give us the information that you are looking for. So it was quite a corrective move by the judge, and it sent a stern warning of saying, let the witnesses go in and out of the courtroom in a proper manner. The only time in which you are going to get any news is from the witness or the evidence which is going to be stated inside court.
I think I got the sense yesterday, at least from just observing public interaction around that particular incident, that perhaps some in society don't fully appreciate the psychological impact of actually taking the stand, be it you're an accused or even a witness, because some would think as a witness, you're not there to be badgered by some of the council members, but nevertheless, one would think that such a case of enormous public interest would really make someone very, very scared and quite overwhelmed.
Definitely. When the person is coming to give evidence, which is such of a crucial nature and such weight, and there's the potential of sending someone behind bars or setting someone free. And there's also the public perception with the invent of social media. People are then prosecuted or decided or judged there and there. And you don't want that to happen in any of the witnesses who are going to be there. And it ends up blurring the real point of why the witness is there, which is to extract and tell us what exactly happened on that day. And there are also going to be elements in which, during cross-examinations for such, there are going to be mistakes. And they also run the risk of being branded a liar if there are certain inconsistencies with your statement. So all that particular pressure, adding on that you are going into an environment that you are not used to. A courtroom is not a nice place to be. It's only nice for maybe for the legal practitioners because that's where they go and do their work. But for every single other person, it's very intimidating if even the manner in which you say you are in this one small cubicle and the focus is on you and everyone is waiting for your answers to scrutinize them at the end of the day, either to brand you as a truth teller or as a liar. So definitely the pressure is there to make sure that you perform. So we don't want any other external influences which are going to come in.
How would this incident jeopardize the state's case, if at all? Because one would assume that going forward, some of the witnesses might even request as well that they have their testimony in camera, similar to what we're seeing now with Tumelo.
Firstly, someone is going to the witness box already being apprehensive and saying that I don't want to find myself in trouble. I don't want this thing is going to cause trouble for me. So the level or the ability for you to be able to remember the finer detail is going to matter. If you can't remember the finer details, then the accuracy and the weight which is supposed to be placed on your evidence is also going to be affected. So you may be perceived as a person who's a liar. Meanwhile, simply as a human being, you've simply forgotten due to the pressure which is you are currently facing. So it has a direct impact in the manner in which the court is working. And that is why the court tries so much to make sure that witnesses are so accountable to such an extent that even if they need comfort breaks, maybe due to emotions overrunning, they are given those comfort breaks so that at the end of the day, they come back and they're able to give the information which is going to help us to drill to the truth as to what exactly happened.
Now, let's talk about this particular phase of the testimony now, insofar as the case is concerned. We've now entered the phase where we're dealing with eyewitnesses. How significant is eyewitness as opposed to perhaps the managing of a crime scene by police officers?
Let's remember the end goal is the end goal by the prosecution is that the version in which they are bringing to court is the only version which must be believed by the court, meaning that the accused must be found guilty beyond reasonable doubt. The end goal of the defense is to plant sources of reasonable doubt here and there. So you are done with the third or corroborative evidence which will come from experts. Now you are dealing with eyewitnesses, people that were there, experienced the emotions of being robbed, experienced the emotion of seeing someone they love lying lifeless or being shot or being hurt. So at the end of the day, you then want to say, I want to be able to place the accused inside that particular venue. I want someone who's going to be able to detail the finer details or the sequence of events as how they got in, what is it that they uttered, certain features which are only limited or unique to the individuals which are currently the accused, to help us piece together these things. If there's motive that can be derived from such, we also want to hear that, which is why you'll hear the prosecution asking, what did they say? When they approached you, what did they ask you? What did they point you with guns? When they pointed you with guns, what are the other things or actions in which they then engaged in? So what you are then doing with this third piece of the puzzle, you are bringing in now emotions and taking us back to that fateful night, not as a person who's going to try and piece back the pieces later, but as a person who was actually there, who can be able to narrate the story as to how everything went from A to Z.
On the state side, it doesn't seem as if there's clear indication as to whether more witnesses from the House will be brought in, particularly the ones that are of great interest, be it Kelly Khumalo, her mother and her sister, and even Longwetwala. There's no clear indication as now. And if anything, if we should read much into what we saw last week, when we had Sergeant Mthethwa attempt to bring in Kelly Khumalo's mom's name, they were asked to expunge that from the record because the advocate Baloyi was not prepared to actually give a definitive answer as to whether they would be there. Is the law prescriptive in this respect as to perhaps saying that you must bring everyone that was in the House, they need to take the stand, or in this instance the state does have that prerogative to say we'll bring perhaps two when it's just the two gentlemen and leave out completely all the others that were in that room?
In fact, the case in this case is what we call the dominus litis. So it's their own strategy. They can choose what they want to do with it, except that they must be able to suffice this very hard and important test of providing evidence which will be found the accused, which are in the witness box, guilty beyond reasonable doubt. So the state is playing it safe by saying, I do not want to bring the high-profile witnesses. Let me say that with inverted commas. I want to bring people who are going to be there, lay this particular foundation, and be able to corroborate whatever that you are saying or that you have stated in the earlier stages. If needs be, then we can bring in all the high-profile witnesses to come in and collaborate further what has been stated. But if I have two or three witnesses who are going to go in and say the very much same thing, which is in line with their statements that have written earlier or their what they've attested to, then I've surpassed my test in terms of the actions or things that were actually going on in that particular crime scene. But what does that mean is that the defense can then apply and say, there are other witnesses which were inside that particular room that we haven't called. If you are not going to call them, can I subpoena them? Because I also want to hear their version. Maybe my instructions are much more different with what you have or your state of events or sequence of events. And in order to be able to prove that, I need those witnesses to be able to come in. So the state in this case is saying, let me build up my sequence of events in a much more nicer and easier way by bringing all, not to say non-important, but the ones which the spotlight is not on them. Certainly they're going to come in, state what happened, and be able to lay a very nice foundation of the sequence of events. And only then at a later stage, I can bring the high profile of the controversial witnesses that may come either collaborate, make the state's case stronger, or make it weaker, depending on what they say.
Okay, so meaning the defense in this respect, as you say, can actually do something about it. So they wouldn't necessarily be, their version would not be lost to society or the court because they can be subpoenaed.
Not at all, which is why it was important for the defense to then say, tell us what's your intention with regards to the statements which are contained in docket number 2. We need them because the emergence of docket number 2 is important. At the end of the day, with that emergence, you're going to have 3 versions of the sequence of events or evidence. Firstly, statements which are contained in docket number 1. Secondly, statements which are contained in docket number 2. And lastly, the statements or the evidence which is going to be stated inside court. All those 3 events or statements or sequence of events must speak to each other. There must be no contradictions. Yes, there may be minor contradictions here and there, but they can't be major because if they are, it proves that somewhere, somehow, between those statements, someone was lying. But if they all talk to each other, it proves consistency, it proves probative value, and it proves that the weight which must be attached by the court to the evidence of that particular witness that has passed all 3 must be much higher than the other ones because it proves to us that they are indeed telling the truth. They haven't altered anything. They are simply regurgitating the sequence of events as they happened on that particular day.
Mpumelelo, as always, thank you very much for your time. That's legal expert Mpumelelo Zigalala from Zigalala Attorney.